Sarah gave you everybody's overview, but I'm going to invite each of them to tell you a bit about how their work intersects with siting. In some cases, it's super obvious. In some cases, it's great to have their path. So before I ask them that, though, I'm going to share with you that I first met Sarah 15 years ago when we were working on renewable energy siting here in Michigan after the passage of the '08 legislation and having really robust conversations in the Wind Energy Resource Zone boards about what does this mean for your future and how can your community see opportunities as well as challenges in renewable energy build out? So this is an area that's really near and dear to my heart. And then I also think I don't think we've said the words yet. So I'm the first one, mark the time, it's 10:44. There's a lot of overlap with data centers and the way that we are seeing people and companies do their engagement. I'm sitting here thinking I wish that there's a bunch of the data center developers that could actually hear these needs for transparency, these needs for community engagement. So anyway, I'm just going to be the one who said the data center words first. So I'm going to start down at the far end with Sarah Mullkoff and ask her to talk a little bit more about her background and talk about her engagement with siting.
Excellent. Thank you, and good morning, everyone. Thanks so much for including me and on this fabulous panel. Really glad to be having the discussion today at this junction of time. Just by background, Sarah Mullkoff, I've been at the Michigan Public Service Commission for about 9 years in a couple of different capacities. I won't go into a ton of detail, but my role in all of this, as past speakers have alluded to, I lead the section that reviews these siting applications that come before the commission, of course, under limited circumstances. So how do we intersect with it? We're the team of subject matter experts. We're the team that has deep background in all our aspects of engineering design, environmental review, public benefits, and beyond. So I've got the technical team that reviews these applications. But more practically speaking, how does one interact with us? I think I'll just reflect on I was at a public meeting last week, and I think it's fairly common. Somebody meets me, say, nice to meet you. I hope I never have to call your office. I hope I won't be calling you. And that's generally the sentiment, as has been expressed, is we're the option that's there if you need us. And so I think the talks today will kind of elaborate on how and when that actual backstop or safety net authority has been implemented. Albeit the caveat, of course, it's early in implementation and time will tell. And of course, my other caveat as state government employee is that the views expressed here are of my own. I'm only speaking for myself. And of course, as the Chair Dan Scripps spoke earlier, decisions on any of these matters are those of the commission as a whole. So the commission orders do speak for itself. So I'm just speaking on my behalf.
Great, thanks, Sarah. Catherine.
Thank you. I'm Catherine Kaufman. I'm a municipal attorney at Bauckham, Thall, and Kalamazoo. We are the general counsel for the Michigan Townships Association. So in that capacity, we were involved with Public Act 233 legislation, which we opposed, and now we live with, right? And moreover, we have over 200 municipal clients, largely rural townships throughout the state of Michigan. The Michigan Townships Association, there's 1,283 townships in the state of Michigan. We represent 1,240. So when this industry started to explode, especially in southern Michigan, where our office is based in Kalamazoo, it's heavy in that part of the state. So we have been involved way before Public Act 233. I've had several clients approve projects before Public Act 233, and now we're in the realm of helping municipalities decide what of the options that Madeline laid out in her prior presentation you're going to do. And just a quick observation from the ground floor, standing out in the field, watching the new bad fencing going in, telling you rip out 8,000 acres of bad fencing, that kind of thing. Unless a municipality has had this project or this industry come to them yet, they don't really understand Public Act 233 or how it may apply. So each particular case, you go in, you explain the options, and you deal with what that particular municipality feels about that industry, that project, and where they're going. So every situation is new. Every situation is a challenge. Every situation is a challenge for the elected officials or the appointed officials. If you're just a planning commission member and you're dealing with one of these projects, it is a huge lift. So that's what my job is at this point in time.
Thanks, Catherine. Laura.
Thanks. I'm Laura Sherman. I'm the president of Michigan Energy Innovation Business Council. So we're a clean energy trade organization. Our members are a lot of the developers who are building these projects, developing these projects, owning the projects. We were involved very heavily in the crafting of the law, contrary to Catherine. We were very supportive of it, along with many of the folks in this room behind the scenes in crafting it and in a lot of the provisions that are there. And then we were very involved at the commission in developing the rules that Sarah and her team are now actually implementing, and in making sure that those rules made sense and would work for developers, would work for local communities. I think that process, I think I counted up, we submitted like 30 sets of comments and had, I don't even know how many work group meetings, a whole lot, to make sure that the folks who Dan mentioned had been hired and Sarah had hired really understood from, Catherine's perspective, from the township's perspective, how this was gonna work. A land use permit and this process was very new. And so developing all of that was quite the path. And then now we've been supporting our members, working with Sarah's team on their applications, but also, a lot of them still going through the local level. And so continuing to support those efforts, as well as making sure that trying to support the efforts to uphold the law at the court. And we don't need to touch on that today, but.
Great, thanks, Laura. So each of you talked a little bit already about how you intersect with the law, but I'd like to dig in a bit more. We've had some great presenters, hearing from Dan, hearing from Madeline about the legislation, but I'd love to hear from your perspectives what you think is something either that is a big standout for you or something, an aspect that you want to make sure that this room understands about the legislation. And Laura, why don't we start with you and go back? Laura has to go first. She can handle it.
I think and I think it was discussed a few times today, one of the things that we're hearing a lot is that the law basically just creates a backstop. And I think one of the key pieces, I've forgotten who asked this question, but what's in it for developers not to just skip the local process? They don't want to go to the commission. This takes a year. One contested case is going to cost them $100,000 maybe in legal fees at least, right? They got to hire expert witnesses. They've got to learn the MPSC process. It might, as I said, take a whole year unless they can work collaboratively to get to a settlement. And so I think what this does is it creates a framework where everyone is motivated to work at the local level, and there's a backstop. So the developers have an option. There's a backstop there, but it's, people really, I don't think, aren't really creating CREOs, but what they're creating is there's a negotiating table. So that table, there's all these pieces from the law that could be added in. There's things the locals want that could be added in, but there's sort of a backstop that if you get to a point where you can't reach an agreement, there's still an opportunity and a project doesn't just die, which is what was happening before.
I think it's really interesting because we are sort of on opposite sides, but I echo everything she just said. Because every municipality, when a project comes to them, somebody's going to be in the community for a period, a year earlier, already asking, what's your zoning ordinance? What do you have? Let's talk together. Let's try and figure this out. Before Public Act 233, that was just a total, either I can approve you, I can deny you, and we had the ability through a special use approval to enforce conditions. Nobody's mentioned Public Act 234 here today. Public Act 234 also changed landscape, which amended the Zoning Enabling Act, which said if you approved a special use after 2021 for one of these projects, you cannot renege or revoke or modify that if they've spent 10% of their project cost or $10,000, whichever is less. $10,000 is I stand up and get out of bed in the morning, okay? So that changes the dynamics tremendously. So when I am talking to my clients, many of whom have always been like, and I'll just briefly say, I am God's special chosen township because of XYZ, right? You don't understand that I don't want this here and I don't need this here because I am so special. Whether it's lakes and streams, whether it's my farmland, whether it's my natural resources, whatever it is, I am special, so we don't need to talk about this here. That's where I start, from below ground, right, to have this conversation. Having the backstop of the law, whether my clients listen to me or not, because a lot of times they won't, okay, because they just don't want to believe this is happening, all right, allows me to always put into the framework, well, we can develop a workable ordinance, but it needs to be workable. And as I describe it to them, it has to hit the sweet spot. What's the sweet spot, okay? Where are we going to move that we can vote on as a township board, because it's a zoning ordinance amendment, right? Zoning ordinances are subject to referendum in townships and counties in the state of Michigan. All right, so if I adopt a zoning ordinance amendment, it's a workable ordinance, and enough people in my municipality get riled up about it, they can put it to a vote. All right, so that's the other side of it. Backstop, state law. I do a workable ordinance, everybody hates it. I can completely flip my township board on a recall. I can repeal that ordinance on a referendum. So in that framework, I am now working. The whole township board flips. We go from having a workable ordinance, everybody, 5 of them recalled at one time, and we're going to go with a no. You know, so I have to lay out, just as Madeline explained, here's your options. Default to the state. And if you don't want, I've had a township where on a zoning ordinance referendum to allow workable, it went on a flip. They lost half the township board. They are saying just go to the state. We're not going through this anymore. It was a civil war, okay? So I appreciate the backstop because it is this is me personally. I'm not speaking on behalf of the MTA or any of the townships that I represent. It's a frame. We're now within a parameters, okay? We're within parameters. And so if the township board denies something, whether it's a workable ordinance, whatever it is, that company has some ability, and that is some leverage on my side to getting to a workable. It's not always possible to get to a workable. You're going to spend days at public meetings hearing people tell you why you're a horrible person and much more. My law partner has received death threats, okay? I have received physical threats of violence. We have people trolling us on, YouTube. We have all of it going on. And then you think about, well, she's an attorney, she's getting paid for it. What about these people who are an appointed planning commission? They're just appointed planning commissioners. And they're getting that kind of violence and hate and vitriol directed at them personally. They're having people send them emails saying, I know where your kids go to school and I know when their bus is picked up. This is what is happening. So I appreciate Public Act 233 because now at least we're in a framework, okay? And you can do all these things out in the world and do whatever you're doing, but we still have to make a decision on this at some point. And if our decision is just go to the state, tell them to go to the state. We don't want to argue about this. That's there now. We didn't have that before. So that's there now. And I totally agree. It's been disincentivized to go to the state because of all the reasons Laura just said. But at some point, whether the municipality decides to go forward or not or whatever they're going to do, there is the framework we're working within. So I do appreciate that.
Yeah, thanks, Catherine.
Mm-hmm.
Sarah?
Yeah, thank you. Going back to the maybe hallmarks of what stuck out from the legislation, I'm going to take a slightly different tack here on the more technical side of things. So what I would underscore, what I think has been a major success of the design and implementation of PA 233 is that it was thoughtfully designed. A lot of the criteria really models other areas which the Commission has issued citing authority. So as Chair Scripps referred to earlier, we've had citing authority for liquid and natural gas pipelines for almost 100 years, transmission lines for nearly 30 years. This is not new to us. And so a couple of the things that I wanted to highlight is that there's actually quite a lot of parallels within our PA 233 citing evaluation within the law that mirrors similarities with transmission and pipeline cases. For example, they each ask that there must be a demonstration of public need. In renewable and battery cases, the justification must be the public benefits justify the construction. So very closely akin to a demonstration of the public benefit or public need. 2, there must be considerable feasible alternatives in renewables and storage siting cases. Similar to pipelines and transmissions, they also must analyze proposed alternative routes. Third, with renewable and storage cases, there must be no threat to public health and safety. That's the exact same language in Act 9 for gas cases and liquid gas cases, and the same across transmission siting cases. Shall not include any threat to public health and safety. And fourth, across all three of those statutes is some kind of mitigation to environmental impacts. So those are four areas which are common across those areas, and I bring it up really just to show that the Siting Act was thoughtfully designed, and it drew upon existing framework that the Commission does in other infrastructure types of cases.
Thanks, Sarah. Maybe we'll start with you. What I'd like to talk about now, before we move over to where we're at kind of today, I'd like to spend a minute on the difference between the legislation passing and what you thought was going to happen, and then where we're at with implementation. So Sarah, kind of curious if we can start with you about what is surprising you about today versus when the legislation passed.
Thank you. I think we could all spend all day kind of recollecting on what we thought might happen, how we think it's going, but that is the question of today. So I'll try to be succinct. My personal experience, I wasn't involved with the policy side of the passage of the law. I, as the staff, comes in from the lens of we're here for implementation. The Commission often says we're a creature of statute, so after the law is passed, we're here to implement it. So what has early implementation over the last 18 months looked like? I will reflect that from the onset, from passage back in 2023, I had expected this will continue to be controversial. While it's a strong solution, myself and my colleagues, I don't think anybody guessed or assumed it would be a smooth ride from here. That's proven to be true. It's continued to be controversial and, of course, pending litigation, which we're not going to talk about. So there's a lot of twists and turns, yet also, I think, notable progress. And so what's surprised me or stuck out, I'll say there was a point in the not so distant past, a year and a half ago, that in one world I envisioned upon implementation date, which is November 30th of 2024, December 1st, our doors would be open for business and the cases would come in immediately. In one world we envisioned that. There was a lot of pent-up cases we had been tracking and hearing about, and they were basically eligible to come to us on that date if the circumstances allowed. And they didn't. They didn't in November, December, January, February, March, April, May. It wasn't until June. It wasn't until June, about 6-7 months later. 6, 7? Oh. And so
that makes you old,
I
Sarah.
have a young child, sorry. Anyways, what surprised me was a little bit the timing of the cases, the cadence, and what type. So I think with type, we mainly did expect solar, and that's what's remained to be true. Of our 9 cases, 8 of them are solar projects. The timing and the cadence was a bit of a mystery, and honestly, we weren't even sure how to staff up accordingly. So in hindsight, I'm so thankful that we had that build period upon when the new staff was hired in November of that year through our first case. We got a lot of time to study, train, do site visits, do additional engagement, get out in the field, do a lot of additional research and alignment with partners in this space. So what has surprised me? It's the numbers now at the pace of which they're coming in. It seems like it was a bit of a ramp up. Developers, in my opinion, were kind of waiting and seeing. No one was quite eager to be the first case. And then once there was a first case, then shortly thereafter a second. A little bit of pacing, a lot of that still, let's wait and see from my perspective of how I think they were observing the process. How's the Commission going to handle this? So a few more months of build out. And then came the end of late last year, early this year. They keep coming in really expedited numbers. And so I think it was a bit of a slow ramp up, and now we have nine before us. We're aware of 3 more that are really likely to come in the next 3 or so weeks too. And so it's been an exponential increase that I didn't entirely expect.
Thank you.
I think the same. We thought at our office that when the day was, the effective day, that they were going to be getting slammed with applications because we've seen so many townships just reject or turn down or deny. So we were a little surprised with that as well. The other thing I'm personally surprised is, it's just me personally, not reflecting the MTA or anything, is how much the public still doesn't understand about this law. There's been extensive educational efforts through, many of the organizations that I professionally belong to. Maybe, as Madeline said earlier, we nerd out on this stuff, so I feel like it's totally, everyone is in the same place as me on this. But I am still surprised that every municipality we go into, they're refusing to understand the legal framework we are working within, even though I explain it, even though maybe Madeline comes and explains it. They're just rejecting the reality of Public Act 233, which is, to some extent, preempted your local control of zoning. And that's been surprising to me, and the fact that I have to, every single community I go into, start from ground zero and establish that, and, am not always successful in getting my message across.
I'm going to combine these two. So I was also surprised on the timing and the number of applications, and Sarah and her team kept asking me, poll your members, how many projects are coming, what kind, when, what? And I have multiple spreadsheets because I kept doing this, and they all indicated many more projects than she's gotten and earlier. And so I think, and people were, I think, thought they were being actually conservative in their estimate, like, hopefully we'll be able to work with the township on this one, but not on this one, so we'll only tell you one instead of two. So to me, I think it is picking up. So some of it is that it just took a while to work through the required local processes. But I think also what we had said before about the space for a workable ordinance is actually allowing more to go through at the local level. The other thing I'm really surprised by, and this is similar to Catherine's but with developers, is I think everybody understands fully how the MPSC process works. And I thought that when we wrote this into law that it was to be a contested case process subject to blah, 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 the same as all of them, that they all knew what that meant. Turns out that's not true. Turns out the developer community had no idea what that meant. If they haven't done this in Michigan, it's mostly the utilities who file projects at the commission, not developers. And so they have done this in other states maybe, and it's totally different. And so having to do so much education on, well, no, you really do need to hire a regulatory attorney, and I have a list, and some of them are here, and I send them their names, and I say, go talk to them, please, you need help, and then you need an expert witness, and all of your information has to be in up front, and here's how discovery works, and it's just, I thought that this process was everybody knew, which is only because I'm deep in it, and of course everybody doesn't know, and so that's been interesting to me, is sort of working through with Sarah's team the incompleteness and how the process works has been quite the learning curve.
Great, thanks. I'm excited to turn to a portion of questions that we sort of came up with naturally while we were doing a little panel prep, which is basically, what do you wish the other segments involved in this siting and development work understood? And so we're going to start with Laura, and this sort of started naturally in the course of our conversation with each other, and I'm really interested in it. So Laura, I'm going to start with you, and I'm going to ask you, what do you wish the PSC knew, and what do you wish local communities knew represented by townships, but also understanding that, we're fortunate to have Catherine here, and there's also other conversations with, other parts of local government.
I'll start with the townships first, maybe. I think the first is something that I've mentioned a couple times, that developers also don't want to go to the Public Service Commission. So they don't want to skip. They would rather do this at the local level. There are many benefits for them to doing it at the local level. And so I think the assumption that they would rather just skip that part is not correct. They would rather come up with something that works. I think there's also, at least in some cases, if you can take the angry mob mentality out of it and have a conversation behind closed doors, for example, through the Public Service Commission process, there's more space for compromise that you can find. So I think some of these folks, when the townships and the developer are able to sit down at a mediated table that isn't filled with people who are threatening them and their livelihoods and their families, you can have a much more constructive conversation. There are certain things that can't change, which is the other piece. There's, you're in an interconnection canoe at MISO, there are certain things you can't change, but there are other things that you maybe could change with certain projects. And so those pieces are important to think about if you can sit down, calmly. I think what the MPSC, and maybe some townships, I think we've had a lot of discussions about certain aspects of the rules related to brownfields, related to alternative sites, related to the labor provisions, and that, I think there is shared understanding now, but that was quite a bit of education. Also around other local permits, and I bet that Catherine could talk about this more than me, but there's a lot of other local permits required, and sort of things like drain commissioners and all of that. That was huge sort of education for both myself and for, I think, the MPSC staff.
A lot of learning. Catherine, same question to you. What do you wish the MPSC understood, and what would you like the development community, the clean energy community to know?
I think I'd like the clean energy community to know, and I think hearing from Laura that many of them do know, these are elected officials or appointed officials. If your decision is of special use made at the Planning Commission, these are just appointed people. They're not elected. God willing, they've had some training, okay? God willing, they call their attorney to the meeting. But none of this is a certainty, okay? And please be respectful of that, and, try to, and I have a lot of people that just talk to the township supervisor because they think he or she is the boss. No, it's just one of 5 on a township board. So if you align yourself and hitch your wagon to that township supervisor, and he or she's in a minority of 2 versus 3, you've just made the wrong selection, okay? So understand the structure of the township government that you're going in front of. Understand what their issues are. Talk to their drain, if it's an agricultural community, talk to the drain commissioner, know if you're getting into any drain areas, talk to that road commission, figure out from that road commission what they're gonna need, look at their roads, see what bad shape they're in, and see if you're gonna have to help pay for some of that. Would that be part of your discussion of a workable ordinance, that type of thing? We are talking very rural townships, and so that people know in rural townships, this isn't their full-time job, okay? They do other jobs. Township board meetings have traditionally been at 7 or 8 at night because the farmers farm during the day, okay? So you gotta understand what you're coming into, and you've gotta understand how to be respectful of that. And many, many, many times, the project is permitted by one company and then immediately sold off. Okay, so when that project is permitted by somebody, there's been a rapport or an established relationship made that on the day that project sells, boom, it's gone. Okay, and so now, as a township of 5 people that do other jobs and farm all day and run a trucking business, and then at night they're trying to do this. If you switch, and I represent Lee Township, which has one of the largest projects in the state, Sunfish 1 and 2, 809 megawatts. It was permitted as one project, it's now 2, but they have another 100 megawatt project too, and now they're getting battery storage. What this has done to that township in terms of managing the project, and we'll get to that, but I would just like the developers to understand that's who you're dealing with and be respectful of that. What I need from the MPSC, and obviously the litigation was just, the hearing was just the other day. I have townships that want me to guarantee to them, well, we're gonna get our intervener fees. If we turn down this project because of our workable or whatever we're gonna do, are we still getting our intervener fees? And that kind of, I'm not sure on that, so I'll just let Sarah help me on that. But understand that the intervener fees, and then we need to know, as a municipality, how do we intervene in a case at the MPSC? Because none of us have done that. So that would be helpful for us, because everybody wants to guarantee they're going to not screw up their intervener fees.
I think I heard that Laura has lawyers for you.
I think she has lawyers for her side.
She's not going to give me her list.
Well, 2 parts, but I think it's actually going to be a little similar responses too. So what do I wish the developer community knows about our MPSC implementation process? As Laura already alluded to, we've really come a long way. But the AFIP, as the application filing instructions, AFIP that we refer to, it's a highly set of highly technical and very detailed set of instructions. So I do recognize it's been maybe a bit of a learning curve for developer communities and the consultants working with them to really understand the detailed amount of information the commission is indeed asking for. Each and every one of the prompts contained in those 90-some pages are information that we're seeking to understand the full and complete evaluation of the application, and that corresponds to like a list of 370 or so line items that our staff kind of verifies. It's extremely detailed, and we do a very judicious level of review. So I think in time, through lots of productive conversations with developers and your members, Laura, we've gotten further with kind of a shared understanding of what the expectations are. But albeit it was challenging, I think, for both sides to kind of, with some of the initial applications and the incompleteness memos that resulted from them. So I do wish, and I hope that they continue to study it in detail, and please reach out to us with questions. That's going to be my same advice to the townships too. We're always available. We always answer the call and the email, which is offers to me, and help us understand these new and very complex instructions. So for the township's perspective, there is a line within our AFIP as well that suggests township supervisors may reach out to MPSC staff to request a meeting to answer questions. And every time a new application is filed, we do outreach to the township supervisor, which may or may not be the.
But it's somebody.
Yeah. Right, the designated point of contact, and we do offer to meet in a similar manner. It's been taken up a couple of times, but not always. So and just a note reflecting on your comments of how truly challenging the planning commissioners' jobs are. We as staff have been on quite the learning curve ourselves too. Our bread and butter work is energy and economic regulatory policy. Venturing into land use policy has been a lot to learn, to say the least. And one of those tools that we use to really start to think, what is it like now to kind of wear the hat of a planning commissioner? One of the tools that we used was the Michigan State University Extension Michigan Citizen Planner Program. We all underwent that program. Shout out to Spartyville, the mock township, to really learn and engage of what township supervisors and commissioners must go through with basic planning and zoning 101. So just acknowledging there's been a learning curve for us too, but my takeaway to both developers and the ALUs is you can reach out to staff right at the beginning of cases as they're filed. And another maybe misnomer or misunderstanding is you can continue to talk to staff throughout the case process as well. I understand the MPSC contested case process might sound big and scary. There's litigation around it. I mean, it is an administrative manner in which cases go through. Nonetheless, the parties are always allowed to talk to each other. We don't always have to bring all of our counsel together. It's oftentimes technical experts to technical experts, and that goes a long way with, I think, some of the greater goals is reaching more compatibility and seeing that we're not too far off from each other's positions.
Yeah, I think that's right, Sarah. And I'm just going to double down on Sarah's comment because, of course, MPSC works for all of us. And so it's always okay to reach out and have a conversation. And they will tell you if you're in a lane where they can't speak because of legal reasons. So Sarah, we're going to start with you and come back. I'd like to spend a minute on, from your perspective, what does success look like? And what is one of the elements in this policy framework that you feel like is working?
Yeah, I love this question. I was thinking about it a lot in the last few days in preparation for this. So, as we all know, it's been a wild ride. Roller coaster was used, right? It's been controversial and ups and downs. But nonetheless, I think we're resilient overall, not just the staff implementing this, the developers, all of the challenges that we've been facing are abundant, of course, but there's resilience within that. I think success looks like ultimately more trust building and a authentic and deeper understanding of the commission's process. And so in one way, the success is that developers and townships alike have a deeper trust of who the MPSC is and trust them with their authority to implement the law as directed by the legislature. So trust. Second is efficiency. I think in due time, efficiency. In due time, these processes may not be quite as lengthy as they are, and so success may be like actually seeing a certificate granted in the 12-month time frame. And third, of course, is issuing certificates. And so remains to be seen how and when and timing of when initial certificates could be granted and what they'll look like if they contain similar conditions as within the cases. But ultimately, the success of this is like a durable model that results in certificates for well-qualified projects, and in the longer term, durability overall, like mutual trust across all of the partners in Michigan that the Commission has set and established a durable, transparent, and fair process.
Thank you.
Well, I think success, and this is my opinion only, I'm not speaking on behalf of anyone else, but comes in the municipality deciding within itself what it wants, how it wants to deal with this industry. And, you know, the range of options as explained by Madeline, and spending the time to do that and think about what their community is, look at their master plan, figure out how the industry might fit within them, and be able to exercise whatever decision they want. That's primarily, in my experience, been a workable ordinance, but it's not always gone that way. So having that conversation, deciding what they want it to be, and as a municipality, executing and moving forward. That's what I think is the best approach.
Thanks, Catherine.
So I guess slightly different take. I would say I agree with Sarah on the sort of durability. So I think the success is this lasting and becoming sort of standard practice. But I would say more than that, having it become unnecessary. So I think having this process in place for long enough and with enough education of everyone and enough conversations that come to good, workable opportunities so that we don't have to use it. So I'd like to see the numbers at the commission go down rather than up. I think that would be ideal, is if we can do that. And then if they do go to the commission, I'd love to see some of these projects actually come to settlements, as in not take 12 months, not spend $100,000 on each side, not get super contentious, and instead just come to an agreement in a different place. If this can create a table for an agreement, then that's good too.
So I'm going to go a little bit off script, but don't worry, guys, you'll be fine. Because I do think that, to me, the core of this conversation is how are we communicating with each other, and how are we talking to communities about what they want to be in the future, and then how do we figure out land uses that are compatible with who the community wants to be and how the community thinks about their economic future. So I just want to spend a second, because I think you are all just incredibly deep experts. I'd love to understand from your perspective, who do you feel like are effective communicators about, you know, the challenges that are in front of us right now? And before, I'm going to give you a second to answer while I pontificate a little farther. I find, you know, Catherine sharing the description of the types of challenges people are having right now really horrifying. And I've had this conversation. It's not just local township officials. That's just awful. It's also state government officials. And it's also just interested parties being involved in these things. So I don't want to characterize any particular group. No particular group is special. However, the rhetoric has got to come down, and we have got to figure out how to hear the person on the other side and understand and sit in their seat once in a while and wear their shoes once in a while in a much more acknowledging and open manner. This is just, it's got to change. I'm really concerned about where this is going, and figuring out how to come to these tables and assume good intent, I think is really important. So that was my pontificating. I'd like to know from the three of you, who do you feel like are effective communicators right now, and how can we double down on that?
I wish I thought this was an issue of communication.
Okay.
I'm not sure I do. I think there have been a lot of efforts that we've been involved with. When I was at Five Lakes Energy, this was the project I worked on, trying to bring groups together. We worked with Sarah, and Sarah's doing an amazing job of this, and her team as well. I'm sure a lot of you are here in terms of bringing a non-biased, a university, an academic message to what do you want in your township? How do you consider this? Here are the options, like Catherine said, thinking about the options. I think you can have that conversation with appointed or self-appointed or volunteer people who are making these decisions in many cases. I think it's very hard to have those conversations with experts, with outside sort of non-biased opinions when you've got 40 people yelling about things that are irrelevant and misinformation because maybe they're not even from the local area. They were just brought in for this. So, you know, I guess I think we still have to keep going with bringing in the messengers who are often not the developers, and the developers know that, and I think they're trying to, you know, work to bring in outside experts, MSU Extension, University of Michigan, those kind of folks. Unfortunately, I sort of think that in some cases, if it's just yelling from one side and the other, we might need to just remove the conversation and have it differently. And that's not possible with Open Meetings Act rules, et cetera, right, in these local communities. And so, you know, in some cases, that may be a place that the MPSC process plays a role.
Yeah, I think that's a good observation. I think Madeline, Sarah, and their team, and MSU Extension have done a fabulous job. The Michigan Townships Association has done a fabulous job of educating. But I have to start with the position of the Michigan Townships Association, which is we oppose PA 233. We did not agree with taking away local zoning control in this particular case or any case. So when you start there, and there's 1,283 townships in the state, and a lot of these projects are going in one of these townships. That is the feeling from the start. And so, you know, in some cases we've been able to move off of that position and have these conversations and develop workable ordinances and get to some type of joint decision, whether through, you know, consent agreements or who knows. The litigation goes to a consent agreement, goes to the MPSC. But in many cases, the very starting point is no. And that's our position. And so, you know, I'm just saying that I'm not exactly sure how far we can move off of that. Some cases, yes, very successful. We've done it. We've been able to convince, not convince, but you know, educate or advise to the local community. These are the benefits, and we cannot underestimate the RCA grant in part of that. Okay, that has really turned the switch for many communities. But in many places, it's just a no, and whatever we can do to stop it, we're going to do. So I hope that we can continue to have the educational component through Sarah and MSU Extension and the Michigan Townships Association, any other municipal organizations, because that's really our only way forward, theoretically, right?
Yeah, thank you. Echo the comments made, and I don't have too much more to add. I think the partnerships that we have in this state are extraordinary. The work that the U of M does, and Michigan State Extension, of course, and my colleagues at Eagle through the implementation of the REA program is instrumental. Collectively, those are the main voices who are helping do this really hard work of on-the-ground education. We know it's not nearly enough, though, with the magnitude of the size of our state. We just can't reach every community. So those are some of the voices. But if I were to offer anything, I think it's that we all need to continue to listen authentically. And some ways in which we try to do that from our vantage is we get a lot of public comments on these dockets too. Folks often wonder where those go. We read them. We do read them. We consider that, and it all helps to impact like the broader decisions. Secondly, we really kind of go out of our way to hear from affected groups. We have roundtables with farmers that want to share their perspectives on a specific project. We invite those kind of conversations. We have conversations with labor groups that really want us to understand what they want out of a project too. And so it really, one approach that we've taken is continued authentic listening and engagement. I think it starts cumulatively to peck away at these broader rhetoric issues.
Yeah, I think that's right. Well, I think this has just been a fabulous conversation. I really appreciate each of your time and energy on the topic, but most importantly, your authenticity and genuine way that you showed up to have this discussion here today. So please join me in thanking this awesome panel.